This is part 3 of the deposition preparation videos for my clients and anybody else who cares enough to watch. So in addition to the rules that I went over in the last part, remember a couple more things about depositions. Remember that it's the lawyer's job to ask the questions. It's your job to answer them. So sit back and let that lawyer ask that question. However, there's going to be some things that are really important in your case that we'll go over when I individually prepare you as well. For instance, if there's liability issues in the case, or there's statements in the case immediately following an accident that need to be addressed, you need to come out and say those in the deposition. If you do not say something in your deposition, you can't really say it at trial, because the other side will make it sound like you're making it up later. Certainly, if the defendant in a case says something at trial that they didn't say in their deposition, I'm going to make a lot of hay about that. So even though you're listening to their questions and only listening to their questions, you want to make sure that everything important gets out in the case, all right? So you make sure you wear that on your sleeve a little bit, and make sure you tell your story. You say why you delayed in getting medical care. It wasn't because you weren't injured. It's because the pain, the real aches and pains and that headache came later that night. The next day you were busy with your kids, so you went the third day or the fourth day, or there's a real reason for that. You need to get that out. You need to say that. And the other thing is that make sure you sit back and listen to questions. So in a slip and fall case, if someone asks you, as an example, shouldn't you look out for where you're going? Of course you should. So you should answer yes, okay? That's not something to be denied, because the fact of the matter is in a slip and fall case, most people are looking out for where they were going. And it's just the fact that the ground was slippery and they didn't see it, or there was black ice in the ground that they didn't see it. So sit back and listen to the question, and don't argue with obvious statements like that, even if you're worried, well, is that going to hurt me later? No, you need to acknowledge that. You need to look out in a car accident case that you're looking out for where you were going. You need to acknowledge, if you're in a workers' compensation case, let's say you had a really bad injury where you got a rotator cuff injury, but 5 years before you had a little shoulder problem that you got one time of treatment on. You need to acknowledge that, because that's not related. That's not what's causing your problem right now. So you need to admit the obvious. Now, the other thing sometimes lawyers try to do is they'll go through detailed medical records and they'll say, did you see a such and such doctor on this day? When you went and saw this physical therapist, what did you say your pain rating was? What did you rate it out of 10? And because it's our instinct to try to provide information, you may try to answer that question. But if you don't know the answer to the question, don't guess. So you don't want to say, I went to such and such doctor on this date and I rated my pain an 8 out of 10 if that isn't true. Say, I don't know. Because the reality is that for most injuries, pain levels can go up and down. If you rest for 3 days and then you go to the doctor, your pain's going to be a lot less than if you would have worked for 3 days or been particularly active, and then you're going to have a pain. So do not guess when it comes to specific days and specific things in medical records. The other thing is that at the end of most depositions in civil cases, the lawyer's going to want to know how your pain is lately. So you want to think carefully before you go into the deposition and think about, how was my pain the month or so before this accident? How many days a week did I have a headache? How many times was I down in the back? How much pain medication did I did? Because they're going to want to know a current or more recent view of the case. The other thing is that what the lawyers are all going to ask you is they're going to ask you, what can you do? What can't you do? What can you do today that you didn't do before because of the accident? Or another way to say it, maybe a better way to say it, is what can't you do today because of the injuries you suffered in this accident? So let's have an idea of that when you walk into the deposition. Can you not play with your kids or your grandkids as much? Did you used to bowl every Tuesday night in a league? Were you a hockey player? Were you able to use your hands more? Did you do more woodworking or knitting or that type of thing? Are you afraid to drive now because of a car accident? Does your shoulder hurt? Can you not raise your hand? Do you need help with dishes and housework around the house? Can you not cut the lawn anymore? Are there real deficits and absences in your life that really are life-changing? Because that's really what's important. In addition to the pain and suffering and the damages that you've suffered, what you want to be able to do is to convey to a jury how your life is different. And then you're also going to want to think about because they're going to ask you, what other witnesses are there that can corroborate this stuff? So if you have bowling partners, if you have a spouse, if you have a sister or a brother or friends that can talk about that, be prepared to talk about those things as well. Remember also that these days, with all of the lobbying and marketing money that insurance companies have put into discrediting plaintiffs in personal injury cases, you do not want to exaggerate your damages. Please do not do that. Because if you do, you're going to get caught. And then if you're saying that your damages were a 10 out of 10 at a particular time period, and they have medical records showing that you went to the doctor and said your damages were 2 out of 10, that's going to kill you. You cannot do that. And so let's make sure in a deposition that your testimony is accurate and truthful as it can be. And of course we're going to do that, but also make sure that there's not other things like medical records, witness testimony, Facebook posts, or something like that that can be inconsistent. That can really damage your case. Speaking of Facebook, if you have a laptop or a phone or something like that, what you want to do with it during the case is throw it in a tub of water. Seriously. What you don't want to do is you do not want to post about your activities and your stuff on Facebook. The worst thing in the world that you can do is have the defendant have your Facebook posts. You testify that you can't do anything, and they have a Facebook post from the same day. I can give you examples. How about the example of my client who posted on his Facebook that he was glad he was returning to work after an 8-month vacation from work. So he said in his Facebook post he had an 8-month vacation, and here along I had thought that he wasn't working because he was too injured to work, and that was going to be part of our case. Or how about the case where I was deposing a defendant who was drunk driving and caused a traumatic brain injury in her friend, and she expressed all this remorse in the deposition about that. Well, what I did was pulled out her Facebook posts that said she joined the I Like to Get Drunk club on Facebook 2 weeks after the accident that had injured her friend that she supposedly was worried about. So let's make sure in our testimony that we testify consistently with the other messages we've put out there, regardless of medium. And thank you. I'm going to end this version of this section of the deposition preposition tape at this time.